dig a little bit deeper into this indictment. Again, we're not talking about guilt or innocence here. We haven't even seen the indictment. It hasn't been unsealed. We're not talking about opinions and hysterics. Talk about the process. And for that, we welcome in Mitchell Epner. He is a former federal prosecutor. He now practices at the firm Rottenberg, Littman, Rich, PC. And you are in New York. So you have probably dealt with some clients that might be in a similar situation as the former president. But this is unprecedented. We have never seen a former president indicted. So what is the normal process? And then how is this going to be different given that it is a former president?
So first, thank you for having me on. Yes, I have walked people through this process before. Ordinarily, the way the process would work is the defendant, if they self-surrender, which is what we have been led to expect will occur, would go to the DA's office, which is in downtown, right near Foley Square, right where the courthouse is. They would be fingerprinted, they would be photographed. The fingerprints get put into a database up in Albany. Once the fingerprints are in the database, then the case can be called in front of the judge over in the courthouse, which is steps away. Ordinarily, somebody just walks up the front steps, which are the famous steps from the end of the first Godfather movie, and they go into the court and they are what's called arraigned, which means they plead not guilty. There is a bail hearing. These days in New York, virtually everybody for a nonviolent offense gets some form of recognizance, which I'm certain President Trump will get. And then he will walk out. He would walk out of the courtroom that day. And then after that, you would have potential motions to dismiss the case. You would have potential motions about what is admissible at trial and what won't be admissible at trial. And then after some period of months and sometimes years, you would have a trial.
What I find really interesting about this situation is you have a former president who has a Secret Service detail, and yet you have sort of law enforcement here with two different assignments. One is protect the president at all costs. The other is take him into custody. How might this be different? And I do stipulate here that you have never seen this because nobody has.
So the thing that I am confident about, having been a federal prosecutor and worked with the Secret Service on protection details, not on presidential protection details, is that the Secret Service, their goal is to protect from physical threats. It is not their goal to forward the personal agenda of the protectee. So the Secret Service will coordinate with the court system in order to figure out how they can both physically protect the former president of the United States and allow the process to move forward.
In this case, we just heard that Representative Jim Jordan and other House Republicans want to call Alvin Bragg to testify. They want to see documents from this case. And you're a former federal prosecutor. This is not federal yet. This is the Manhattan DA. But how unusual would that be for you to have to come before a different body and testify and then provide documents with this case that is ongoing?
So it's highly unusual, but it is not completely unheard of. First of all, the letter is just an ask. It's not a command. If they subpoena, they potentially could get those documents because there's under the United States Constitution, federal law is supreme. There's something called the Supremacy Clause. So federal commands outweigh state laws. And we have seen things along that line when there have been allegations of major miscarriages of justice. For example, in the South during the 50s and the 60s, when there were lynchings and DAs and police forces refused to prosecute. So I don't want to say it's unprecedented. It's highly unusual.
And the last thing I want to ask you about, Mr. Epner, is Ron DeSantis is the governor of Florida. Donald Trump is a resident of Florida, even as he is the former president. And DeSantis called this un-American and said that he would not help extradite the former president. It looks like that's not going to come into play here because it seems like Donald Trump is going to self-surrender. They're negotiating this right now. We already have a day, possibly Tuesday is what our sources are saying. But if that wasn't the case, would DeSantis's decision to not help extradition, would that cause a problem here? Would that be relevant?
It would be relevant, and the only thing un-American about what Ron DeSantis said is what Ron DeSantis said. Under the Constitution, Article 4, Section 2, literally requires that a person charged in the state with felony who shall flee from justice and be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up and removed to the state having jurisdiction of the crime. That is what the Constitution said. For Ron DeSantis to say he would literally not obey the Constitution because an indictment that he's never read, he believes is inappropriate because the status of Donald Trump as former president of the United States means he's above the law. That is un-American. It's shameful. And Ron DeSantis may get political benefit out of it. I have no idea. That's not my bailiwick. But as a person who believes in the rule of law, I believe Ron DeSantis has brought shame on himself.
Mr. Epner, I do have to label that as an opinion. It is your opinion. We brought you on for expertise, but I do appreciate the expertise that you gave us. Thank you for joining us.
Thank you.